Hello, everyone. This is Dr. Jacqueline Rainosek with DTP Leadership Group. This is Hot Topic Bold Talk. And I'm so happy to have my friend Richard Wilson on with me today because he's the one that's going to help you understand what happened with the Supreme Court with the Birthright case. And it has a lot of history to it and a number of things, which I know he's going to talk about. And I think you'll have a much better understanding. Then we're going to talk about the dissent and some of the things that we've realized about what's going on. So, Richard, what I want you to do is just start out and give us a background for Barbara versus Trump.
Sure. And thank you for having me on. Um, the very first day that President Trump was in office for his second term on January 20th of 2025, he signed an executive order. And the order reads in part, among the categories of individuals born in the United States and not subject to the jurisdiction thereof, the privilege of United States citizenship does not automatically extend to persons born in the United States when that person's mother was unlawfully present in the United States and the father was not a United States citizen or lawful permanent resident at the time of said person's birth, or when that person's mother's presence in the United States at the time of said birth was lawful but temporary, such as, but not limited to, visiting the United States under the auspices of the Visa Waiver Program or visiting on a student, work, or tourist visa, and the father was not a United States citizen or lawful permanent resident at the time of said person's birth. The whole concept or idea behind this order, and it was to apply to children born 30 days after the date of the order, was going forward to eliminate citizenship for the children of undocumented immigrants who were born in the United States. That was the intention of
Right.
the executive order. As soon as the order was signed, multiple lawsuits were filed. The state of Washington filed a lawsuit against the federal government seeking to hold that executive order unconstitutional. The state of Massachusetts similarly filed a lawsuit seeking to hold that executive order unconstitutional, which was joined by several other states. But in particular, Barbara v. Trump involved, I believe it is a Honduran woman who was using her first name only for safety reasons, for fear that she might be subject to violence if people who knew who she was. And it basically concerned women who were pregnant or women of children born more than 30 days after the order went into effect who would be affected by the order. They were suing on behalf of their children. And what the lawsuit alleged there was that Trump's executive order violated both the 14th Amendment to the United States Constitution as well as the Immigration and Nationality Act, which is a law passed in this country. It's 8 USC 1401A. So that's how we got to this. The court granted it actually with Barbara, for legal reasons we won't get into here. The plaintiffs sought class certification for all individuals affected by the order, which the court granted, and the court then entered a temporary injunction.
Right. Now, I just want to deviate for a moment because I thought it was interesting and I just want to mention it. Is she a part of the case, the New Hampshire Indonesia community support case?
That is a separate case.
Okay, okay.
But that there is another case. Uh, if I recall the history correctly, In that case, the judge entered an injunction
Right.
applying to all people affected by the executive order. And that case had previously gone up to the Supreme Court, and under the shadow docket, which you and I have previously discussed, the Supreme Court set aside that injunction, saying injunctions can only apply to the parties to the litigation. And interestingly enough, in that order, Kavanaugh wrote that, well, uh, class actions would certify a class of all people affected by the order. Everyone's complaining about the multiple lawsuits that would have to be filed to make this be effective in all 50 states. But class certification under Rule 23 would be a method to accomplish the same result as the court tried to in the New Hampshire case. So
Okay.
ultimately, the Barber case was a separate case. But
Okay.
yeah, they both concerned the executive order and birthright citizenship under the 14th Amendment.
Thank you. And they both were concerned about the fact that there were some people in their community that were pregnant and were not citizens of the United States. They were immigrants that had lived here for a while, and they were worried about their children, what the impact would be. So um, I think there's something really important to, and that I know that you can explain to us. The language in the 14th Amendment supposedly is different from the law that you just mentioned. Could you read the law to us, the 14th Amendment, and talk about it, and then tell us what, because there seems to be, to me, some of the justices that have been in dissent, they seem to be messing with the language when I don't think it's that complex. So
Uh,
please, Richard, give us some understanding here.
sure. Let's work our way up to the most important stuff. So I'll start with the law. And essentially, the law and the language in that law have been modeled after the 14th Amendment. And 1401A reads, the following shall be nationals and citizens of the United States at birth. A. A person born in the United States and subject to the jurisdiction thereof. The 14th Amendment reads, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States. So, the words aren't in exactly the same order, but
Right.
the operative language of both the law and the 14th Amendment of the Constitution are the same. As I read it, the operative terms are the same. Both concern persons born, both read persons born in the United States, and both read subject to the jurisdiction thereof, and both the statute and the 14th Amendment make those people citizens of the United States. So to me, the operative language is the same. I I I don't see a difference in it at all.
Okay.
Um, yes.
No, I was just saying that it seems to me the only thing I see added is naturalized in the 14th Amendment that's not in the law itself. But this has been common practice since the start of our country. So I think it's in many ways very difficult to imagine someone would want to take this away from people that are now living in the United States, no matter what
Well,
their status is.
that's largely what they were trying to do. And with Trump v. Barbara, the way it came to be to the Supreme Court, the names are
Right.
changed. Barbara filed the lawsuit in district court, and in district court, as I mentioned earlier, the judge granted the injunction temporary relief. And yes, just like the Illinois National Guard case, once again, we're dealing with a temporary order and not a final judgment. But what happened in the Barbara case is when the class was certified, and the judge put into an effect an injunction which completely kept the executive order from having any operative effect. Trump then appealed that order directly to the Supreme Court. He asked the Supreme Court to take it up immediately without going to an intermediate court of appeals, and the Supreme Court did so. And as we talked about earlier, there are other cases, and to me, I think probably the best opinion, um, you know, explaining why children born to undocumented immigrants would be citizens of the United States is the opinion from the New Hampshire, the one you referred to
Right,
earlier. And again,
right.
I mean, we're talking about not even a full sentence. All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States. And the court in that New Hampshire case explained there is no reason to delve into the amendment's enactment history, or as explained below, Section 1401's legislative history, or to employ other tools of interpretation to discern that subject to the jurisdiction thereof refers to all babies born on U.S. soil, aside from the enumerated exceptions, because the amendment and statute do so unambiguously. And the idea under the law is if something is ambiguous, you go to other sources outside of that document to try to interpret it. And what the court in New Hampshire was saying, and I agree with it wholeheartedly, is look, we don't have to go to history. We don't have to go to legislative debate when the amendment was put into effect. We don't have to look at any of this because there's only one basic common sense meaning to this sentence or partial sentence. So we're not going to delve into it, all of the history. We're telling you now that children born in the United States to undocumented immigrants are citizens of the United States. I mean, to me, it really is that simple. Although, while I think it really is that simple, Roberts, nonetheless, in his majority opinion, um, decided, took 26 pages to, in my opinion, state the obvious.
Okay. But something that I thought in reading all the documents you sent me and going through the very detail of Barbara versus Trump, I do think it's important to look what Robert did as far as the historical analysis he did, because I think Richard, he gave me at least a better understanding what was happening. I mean, and I'm not an expert in English common law, but what I read made a lot of sense. So I'm asking you to start and let's do a little historical analysis and go in because he starts on page 1 where he said, and then I'm going to give it to you to explain the English common law and so forth, or you can add to what I'm reading. Children born in the United States to parents unlawfully or temporarily present or subject to the jurisdiction of the United States and are citizens at birth under the 14th Amendment, amendments citizen clause. Now, he goes in and he states that very clearly. Then he goes into his historical analysis. I I really appreciated all the stories that he told about English common law and how it came over to America, who came to the United States, and it has been a part of our republic for ever since we started. So to have someone question the birthright of people that are on this earth and are born here is really kind of appalling to me. So would you explain some of the English common law? Because I think it'll be helpful to the readers to understand it. Stand it.
Sure, sure. And without, explaining all 10 or 15 pages where Justice Roberts does so, because then we would end up cutting off the podcast without us really getting to the point.
Yes.
I will try and summarize it, but ultimately, and let me start with this. Um, you know, English common law, when you get down to it, in some aspects, really serves as the foundation of the American form of government and the Constitution. I mean, a lot of the basic principles that gave birth to this country were first enunciated in the Magna Carta 800 years ago. And while there are some principles of English common law from that age that obviously were not the most prudent ideas, concepts of women as property, things of that nature. What I'm saying is not all English common law was necessarily good. There were some good aspects to it. And the one that Roberts really explores the most is the idea that if I am born in a country, I am a citizen of that country. I owe something to that country, and it comes not because my parents are citizens of that country, but because I was born on the soil of that country.
Right.
Literally, the place of my birth fixes the place of my citizenship. And it's that particular aspect of the English common law that Roberts goes into much greater detail, um, explaining, and he takes that up through other circumstances where in the past this country has really varied or attempted to diverge from that basic concept, and that the country, in particular with the Fourth Amendment, has embedded that concept into our Constitution.
Okay. Are we talking about the Fourth Amendment or the 14th?
14th Amendment. Did I say the fourth?
Yeah, that's okay.
Okay,
Listen,
I'm sorry.
at least you're a human being. Yeah, occasionally you do something. All right. So, I think before we go on to some other things that we've discussed and we want to talk about, I think it's very important, maybe right now, if you could talk about jurisdiction, and you may want to get into it later, but if I am born in the state of Texas, I am a U.S. citizen. It doesn't matter. It so happens my mother, of course, was her family was an immigrant from England and Scotland many, many, many years ago. But the thing of it is, I am responsible to the country where I'm born in. So at some point, I really would like for you to go into more about that, and I think you will as we go later on. But you can do it now or later.
Well, and let's talk about it. And I touched upon that, the soil, the jus soli or jus soli, and again, the concept is one of citizenship attaches based on being born in or on the land, and it proves to be very important, um, when you look at ways that in the past people in this country have tried to move away from that concept and move to concepts regarding the granting of rights independent of where you were born, and that concept of the location of birth is to me very important for two reasons. um, First, it doesn't have a skin color.
Right.
um, the ground is the ground. I know people can say, well, yeah, but it could be sand, it could be dirt, it could be grass, but the point is, it doesn't matter what your skin color is so long as you were born in this country.
Right.
And and um, you know, 170, 180 years ago, the country tried to make a big deal of that, of whether or not when you were born, your parents possessed certain rights and were citizens, which were then conferred to you. And that brings me to really the second important aspect of, the concept of the soil as opposed to the individual, and that's that it focuses on, to me, what's most important. We're determining the citizenship of the child. And this concept focuses on the child, the location of the child's birth, and it doesn't it doesn't focus on the parents or the parents' intent.
Right.
I mean, you know, to take it to the extreme, um, let's say you have two children that are born here, and one child's parents leave and return to the country from which they came. The other child's parents remain here for 18 years. Well, what you're doing through this concept of rights, or as the dissent um, focuses on, domicile, an intent to be subject to the laws of that country, is you're imposing the citizenship or non-citizenship of the child based upon decisions they have no part in, decisions their parents make. And that's the second aspect of the citizenship traveling with the land. We're not focusing on the intent of someone other than the child, and we're not focusing on anything else like nationality or skin color. And that second aspect is really important when you look at, the Dred Scott case,
Right.
because the whole concept there was that, um, because Scott was deemed to be property under the laws of a particular state, he was not a citizen, and as a result, he could not sue for his freedom in the courts. It is considered by pretty much any law student to be the worst Supreme Court case ever decided.
Right.
Whatever the political intentions may have been of the court at that time, everyone realizes and acknowledges now that that case was wrong. But I would also point out, and I'm not going to defend that court or Justice Taney, but we also have to remember that the language of the Constitution has changed over time. And one of those changes was brought about by the 14th Amendment. Before the 14th Amendment, in Article 1, Section 2 of the Constitution, the third clause of the Constitution used to read, in determining how many members of Congress particular states would get, representatives in direct taxes shall be apportioned among the several states which may be included within this union according to their respective numbers, which shall be determined by adding the whole number of free persons, including those bound to service for a term of years, and excluding Indians not taxed, plus 3/5 of all other persons. Well, the all other persons to whom the original Constitution referred were slaves. Originally in the Constitution, when you determined representative membership, you didn't count slaves as a full person.
Right.
Um, but to get back to it, after after the Dred Scott opinion and after the Civil War, um, Congress initially passed a law to determine the citizenship of, people in the country, who was a citizen of the country. And the idea was to try to put Dred Scott into the past.
Right.
So the law was enacted, and people began to raise questions about the language used in that statute. One of the um, one of the constitutional law professors pointed out that the language used there focused on things like residence. But the other issue was, okay, if we've got a Supreme Court opinion saying this, um, is the court just going to tell us that our law, the statute, is unconstitutional? So the remedy to that was the 14th Amendment, and was while the 14th Amendment includes so much more than this citizenship requirement, it starts with this citizenship requirement. And
Okay.
and and that's really how that all came about. And that's, again, it finds its origins in being with the soil, um, as opposed to some other requirement that could be massaged to attempt to exclude people based upon their race. 170 years ago, it was, the color of your skin. It was being black. And now, with this executive order, the focus has shifted more towards, I would say, Hispanics.
Right. And it also, the shift has been dramatic about making judgments about any immigrants. There is one thing that I thought was interesting in his history was that he said the Congress, Robert said, the Congress adopts Bates' ideas and puts it into the Civil Rights Act of 1966. I, I think that is an important thing. That particular act is important because it clarifies. And I don't know whether you're saying this act in particular is one that some legal experts have concerns about what was put in that.
Well, what I'm talking about is the statute that predated the 14th
Okay.
Amendment. In the um, After the end of the Civil War. What I'm talking about is a statute from 160 years ago, not the statute that was being interpreted by the court in the opinion yesterday.
Okay. Yes. And I think that's very true. So I do think that though in his history, he does talk about the Civil Rights Act of 1866. And I think that becomes a part of Wong Kim arc. And I'm not sure, but I think that one of the things we could do is I think in his explanations on page 6 and 7, Roberts does some things. So do you need to add any more about what he was saying there?
Well, I really think, but that's because I'm looking at it, the common law made no distinction on account of race or color, which is what we've been talking about. As the Civil War approached, more and more Southern states sought to deny citizenship to Black Americans and openly rejected the common law to reach that result. It was not the place of a man's birth that made him a citizen, but the rights and privileges he might be entitled to enjoy. So that's exactly what we've discussed. And that was the concept behind Dred Scott, was because he was born into a state where he was a slave and not a free man under the Constitution. He wasn't a citizen. He didn't count.
Right. And
Uh,
I'm very thankful. I'm very thankful that the 14th Amendment exists today because I think it's very clear. And I also think the Dred Scott case was a real effort for the Southern states to maintain slavery. So I think what we should do though, because I think the Wong Kim arc is a case that certainly moves the history for us about birthright for children.
and
So how
and
about,
I'm sorry, I agree with
no,
you.
go ahead.
in particular, I mean, the obvious thing with Wong Kim Ark is you're dealing with the application there of the 14th Amendment to um, um, someone who said, look, I'm a citizen, I was born in the country, but it's someone who was not a former slave or not the child of parents who were former slaves. Wong Kim Ark was born in the West to Chinese immigrants who were in the country. He left the country and attempted to return and was denied re-entry based on the allegation that he wasn't a citizen. So his whole point was, look, it's clear I was born here, I was raised here, I've lived here, I'm a citizen. And in that case, the United States Supreme Court, and mind you, that was almost 130 years ago, um, interpreted the very same amendment to the Constitution and said that, yes, Wong Kim Ark is a citizen. And in discussing the 14th Amendment, they pointed out that um, there were certain exceptions to people that were citizens. The one of them were, uh, Native Americans born on tribal lands. Another example was the children of diplomats. Another example was children born to an occupying force that had invaded the country during a time of war, and the children were born in the occupied territory. I
Right.
think an additional example might have been a child born on a ship in territorial waters. And each of those four examples, I don't know that they would be um, I don't know that they would be all inclusive of exceptions to subject to the jurisdiction thereof. But with each of those examples, if you've got children born on tribal lands and they're raised on tribal lands under tribal law, the impediment there becomes subject to the jurisdiction thereof. It would be the same with children of ambassadors. If you visit the Mexican consulate or the British consulate or the French consulate, when you step through the gate, you are stepping onto foreign territory. The land is deemed to be the land that the consulate occupies is deemed to be
Their country.
France or England or Mexico. Exactly.
Right.
So each of these examples involve circumstances where the individual would not be subject to the jurisdiction of the United States. And I think that's the clear example or the clear basis for those distinctions that the justices make in the Wong Kim Ark case. Now, interestingly enough, the way it's been explained to me is that the 14th Amendment is kind of this minimum of people that are citizens, and that ultimately Congress can expand who is a citizen through statute. Congress and the president can't contract it below that minimum guarantee in the 14th Amendment, but they can make additional people outside of that scope
Right.
citizens. And through one of the later immigration laws, um, it has been determined or declared that children born on tribal lands are U.S. citizens. So that would be an example under Wong Kim Ark that's arguably no longer applicable. They are citizens, although the distinction would be they're citizens under a law that expanded the scope of citizenship. It did not look to contract or change the 14th Amendment. But yes, in that case, dealing with an American of Chinese descent born in the country and not of African American descent, the court decided pretty clearly that yes, he is a citizen of the United States.
Right. And I think that's the important thing. I think one of the shocking things about this Trump's executive order is there has never been an executive president of the United States that's ever questioned the birthright. So it's concerning, but yet we do have an opinion. So my question to you is, what are you surprised about that happened in this opinion?
Well, and I would
And
go
then we'll
back and
talk about the opinion. Yeah, and then we'll go back and talk about the opinion.
okay, and I would, with regard to your prior statement, I would agree with you in relation to presidents of modern times. Let's go ahead and carve out the 18th and early
Yeah,
19th centuries prior to Lincoln.
thank you.
But what shocked me the most, again, I focused on that language, that short, simple language from the New Hampshire opinion. What shocks me the most is that this was a 5-4 decision in favor of birthright citizenship under the 14th Amendment of the Constitution. Now our listeners are hearing that it's a 6-3 opinion. Kavanaugh voted with the majority, but Kavanaugh voted with the majority only with respect to the Immigration and Naturalization Act. Kavanaugh, when he touches upon the Constitution, disagrees with the majority about the 14th Amendment establishing birthright citizenship. So it really shocks me that something that should be so simple was a 5-4 opinion by the justices of this country's highest court. I mean, what we're talking about here is you lose one judge in the majority and you have a ultra conservative judge appointed in that individual's place, and they could very well go back and a year or two from now, if the court makeup changed in a certain way, they might very well go back and say, nope, we got it wrong. The 14th Amendment of the Constitution um, doesn't provide for birthright citizenship to everyone born on the soil in the United States. The subject to the jurisdiction thereof means something else, and we're overruling Barbara. I mean, the current composition of this court has over the past few years done away with quite a few um, very old historical opinions that legally were seen as being stare decisis. They were opinions that stand and must be followed by the courts. I mean,
Right.
Dobbs overruled Roe v. Wade. Um, a year ago, the court did away with Chevron deference, where we're supposed to respect the authority of experts within the executive branch when they make determinations. And just last Thursday, the court did away with a 100-year-old case, overruled a 100-year-old case called Humphrey's Executor, which understood that certain executive appointments, because their nature was more legislative, enacting rules and regulations that determines how businesses can operate in the United States, things of that nature. Humphrey's executor said that the president can't just remove executive appointments for any reason whatsoever. Well, that's not the case anymore. In the Slaughter case last Thursday, the court overruled Humphrey's executor and said the president can terminate executive appointments at will. With the one exception being Lisa Cook's case, the court said, well, the Federal Reserve Bank is an independent agency and the president can't remove Federal Reserve governors at will. It's got to be for cause and has to follow due process. But essentially, the court has done away with all of this established case law that has determined rulings in this country in some cases for 100 years, and also has determined the nature in which laws are written with these basic understandings that are being pulled right out from under us. And the point being, with it being 5-4, is with one particular change of a justice that makes up the majority of this court, we could be looking at revisiting this issue in a couple of years, and that's frightening to me. I mean, it's upsetting to me that
Right.
that I view as so basic, something so simple, something that the court in New Hampshire said, look, it's unambiguous. We don't need to delve into legislative history to determine the meaning of these words.
Right
It's
on.
unambiguous. It. Sorry, I'm getting on my
No, no, wait
soapbox.
a minute. I'm supporting you in what all you're saying because my concern is we have never had some of these outrageous decisions that have taken away 100 years of rulings by one swift statement by, about an opinion of the Supreme Court, except under Trump. We have not had that kind of thing happen before. And there's a lot more power being given to the President of the United States to make decisions. And I think it's dangerous to do that. So I'm glad you're talking about it. And I think it is a concern for me as well. Um, I, um, I don't know. What do you think is the impact of this opinion 20 years from now?
Well, as it stands now, assuming the issue doesn't get revisited, obviously the majority opinion from Justice Roberts will be the precedent that the country follows. And, go figure that on a case this important, with many of the cases that were decided in the last week of the court, where Roberts is in the majority, as the Chief Justice of the Supreme Court, he can tap himself to write what he may view as historical or important opinions. The opinion that to me I think will be the best over the next 20 years really is the concurring opinion by Justice Jackson that Justice Sotomayor joins as to part one in the introduction to Justice Jackson's opinion.
And I'd like for you to go into that because I was extremely appreciative of a number of points that Justice Jackson, as well as Justice Sotomayor, supported. And I would like for you to go into those because I think they are so important.
Yes. There are a couple of things here. And first off, let me start with, and I have no way of knowing this. This is what I would characterize as an uneducated guess, honestly. But the only two justices joining in this concurring opinion are Justice Jackson and Justice Sotomayor as to part one. And who knows? Perhaps Justice Kagan disagrees with the opinion. Perhaps she agrees with all of it. But to me, it's important that the two justices in this opinion as to part one and the introduction are minorities. We have an African American justice and we have a justice of Latino or Hispanic origin in Justice Sotomayor. And the Justice Jackson's opinion in part one focuses on certain historical aspects, pardon me, but really focuses on um, how the impact and the idea of distinguishing one group from another um, is being applied in a different way by what the dissents propose. She points out that the justices Alito and Thomas in particular have said on multiple occasions in their opinions that the Constitution is colorblind. Yet she points out in Justice Thomas's opinion, he really focuses on the historical nature of the 14th Amendment and its application to blacks, to slaves born in the United States, and really tries to limit the effect of the 14th Amendment based on that historical concept. And Justice Jackson in part one explains how look, this idea, this concept, this um, the 14th Amendment and the laws that were put into effect um, were not done so solely for blacks. This was not something where the people that created the 14th Amendment and put these laws into effect were so short sighted as to only give it a narrow focus as to African Americans. She says, um, indeed, around the time they gained their freedom, former slaves faced a crisis similar in relevant respects to the American immigrant experience, which is what we're dealing with today. So in part one, she discusses that, and Justice Sotomayor joins her in that respect. Then in part two, a lot of the concepts are the same in that, look, this is colorblind. Um, but part two really touches upon, the speeches of Frederick Douglass. It touches upon, in particular, the African American experience in this country after the Civil War, and she mentions that it's she takes issue with a, attempts to read the 14th Amendment in a narrow fashion that essentially you would pit African Americans against immigrants, because the 14th Amendment would be read to apply to one minority group but not another. I really think that the way her opinion is structured, it is much more effective in making the point that Justice Roberts makes historically in the majority opinion. Um, and it, she touches upon, like I said, it ultimately, what this comes down to me, there's a talk of justices being strict constructionists, and nobody is really a strict constructionist. um, Thomas and Alito want to tell us the Constitution is colorblind, but then in his dissent, in 91 pages, Thomas wants to focus on and distinguish why the 14th Amendment isn't colorblind, that in fact it's only for blacks. I'm paraphrasing it, and I apologize if people are taking offense to the nature in which I'm doing so. But her point is, okay, it's colorblind except when you don't want it to be colorblind, except when seeing color in
Amen.
the Constitution will fit your purpose and your goals. And ultimately, that's what it comes down to. In large part, the way the dissents try to distinguish the 14th Amendment is they look at the phrase subject to the jurisdiction thereof. And they say that that phrase imputes domicile, meaning where do you choose to live and whose laws do you choose to live under? And in using that language, they are basically trying to create some, unfortunately, um, they're defining a broad concept, but they're not giving us any strict parameters on how exactly, at what level does domicile make you a citizen? At what level does domicile make you um, a non citizen and an immigrant? And they really do not try at all to define that. In fact, in a footnote, Justice Thomas says that decision needs to be left to another day. Um, that's not something we need to decide today. And it's problematic to me because when he's interpreting the Second Amendment, Justice Thomas is real quick to focus on the language in the Constitution. Justice Gorsuch, uh, people refer to him as a strict constructionist, but here they're attempting to construct a meaning for the 14th Amendment using a term domicile that is nowhere in the 14th Amendment. It
Right,
doesn't talk
right.
about residence. It doesn't talk about domicile. It talks about being subject to the jurisdiction thereof. And let me give you a simple example. Roberts touches upon it. Give me just a minute. I want to find the language in his opinion. Um, that may have been it.
Well, but I think that's an important
Um,
thing because I think the way they've constructed in the dissent, it brings question, but they have no substance or no legal status that they name or establish for their one word they're using to try to create a difficulty.
correct. And here's the sentence. It comes near the end of Roberts' opinion in relation to subject to the jurisdiction thereof. The question is whether a person is subject to the jurisdiction of the government of a country in which he is physically present, even if he is only there temporarily. Period. He is, period. The point here, let me give you an example. Two children are born in a hospital. They are both the children of undocumented immigrants. One child is then taken by ICE and deported. Well, if he's taken by ICE and deported, clearly he's subject to the jurisdiction. If the country can use deportation proceedings to remove that child and his mother from the country, how can they not be subject to the jurisdiction of the United States? How can they not be subject to the laws of the United States? And to take this example further, the second child of undocumented immigrants, his parents avoid being taken into custody and deported. So, because of their good fortune of being able to remain here for 15 years without deportation proceedings, that suddenly gives him a domicile. And, you know, as the dissent would like to view it, so what? We're going to give one child citizenship because they've lived in this country under its laws. They've been domiciled here for 15 years, but the other child, because they were deported shortly after being born, is not a citizen. I mean, it's there are so many ridiculous outcomes to what the dissents propose. That's
Right.
just a very simple example. But getting back to those two sentences, I agree with Justice Roberts. If I am born in this country and this country's laws can be imposed against me, if I'm going
Amen.
to have to register and obtain a birth certificate, or my mother has to do so for the fact that I was born here, clearly I'm subject to the jurisdiction thereof or of the United States.
Right. And I think one of the things that I do appreciate is the thorough, simplistic analysis of the history, the laws, the 14th Amendment that Roberts did do. I'm a lot of times I am very upset with him about things he's done, like the Slaughter case. So, but I was pleased to see how he thoroughly covered it.
And, and,
And I
and
think, yeah,
I,
let me
go ahead.
finish one thing. One thing that I was concerned about. You know, the Congress does establish laws, so they could establish a law as well that would possibly, there's a question whether they could establish a law that would possibly eliminate what is given in the 14th Amendment. To me, from what I've studied of, I'm not a lawyer, but what I have spent a lot of time looking at with legal aspects is I think it would take another amendment to the Constitution before something like that could happen. Now, I may
It,
be wrong, but that's what I've read several times.
yeah, and I agree with you. As I explained earlier, the 14th Amendment creates this smaller subset. Congress can kind of add, let's call it a flower. Congress can add more petals to the flower. Congress can't
Amen.
pull the existing petals off of the flower. And
Amen.
it's Kavanaugh in his dissent goes into this distinction. And Kavanaugh, and this bothers me too, because Kavanaugh wants to tell us that children born to undocumented immigrants would be citizens of the United States under the Immigration and Naturalization Act, but they would not be citizens of the United States under the 14th Amendment. And his explanation for that is, the idea or the concept that we are taught in law school that the Constitution is a living document, that the language that was used is malleable enough that it transforms to fit each age in which it finds itself. But the problem for me is the Constitution and the law are both made up of words, and they're both using the same words. So if the Constitution, under Kavanaugh's reading, could be interpreted to impose the concept of domicile and to subject to the jurisdiction thereof and deprive the children of undocumented immigrants of their citizenship, then how exactly is it that the Immigration and Naturalization Act, which is also in effect at this very same time and uses the same words, does not also do that? It's nonsensical.
Right, right. And so, but in ending this particular discussion of this case, Barber versus Trump, why don't you end it by saying exactly what, you don't have to quote him, but exactly what Robert has said about birthright in America?
That, to paraphrase it, to condense 26 pages down to one sentence, if you're born on the soil of the United States and you're subject to the laws of the United States, you're a citizen of the United States.
Right. And
And
it
and
doesn't matter who your parents
it
are.
doesn't matter if your mother is here legally or illegally. It doesn't matter whether your mother is here temporarily or permanently. If you were born in the United States, you are a citizen of the United States, and again, the United States would not include, I'm really running far afield, but it would not include a ship flying under, say, a Bahamian flag. It would not include the Indian territories, which are recognized as their own separate tribal nations. It would not include ambassadors and their children, which are not subject to United States laws because of their ambassadorship. But those are the only real exceptions.
Right. Right. And so what I'm saying now is I'm glad we've at least got this decision, but Supreme Court decision, no matter what happened with all of it. I would encourage my listeners. I'm going to give the listings and the links to these court cases, which I always do in my blog. And so what I'm going to do is say Jackson's concurring opinion with Sotomayor is something people should read. It is really a fascinating presentation of what it means for somebody to be a citizen of the United States. So that's my last comment, Richard, but how would you like to end this?
um, I couldn't agree with you more. Being a white Anglo-Saxon Protestant male, I am going to make it clear that I cannot relate to Justice Jackson's experience in her upbringing in this country, or Justice Sotomayor's, but that's why I think I appreciate her opinion so much, is that it really does kind of um, make that point that, I mean, 170 years ago, it was African Americans. Today, it's undocumented immigrants, the majority of whom are Hispanic. I mean, in Alito's opinion, he basically talks about the five countries with the most number of undocumented immigrants. I think four of them are um, Latin American countries. So you know, a lot of the language being used is really code, but I think ultimately the intention here is to try and exclude from citizenship people honestly based on the color of their skin, even though the executive order doesn't come out and say that.
Right. But I think we all know something that this whole process has been one in which Trump nor any nor Thomas and Alito, I think, have done most of the dissents. It's very apparent to me that there is a political agenda rather than a looking at the Constitution, the 14th Amendment, and the various acts that have occurred to determine the decision. And I don't think I'm wrong in saying that because I think there are many times that prior to even having you on my podcast, that I have continued to read Supreme Court decisions and other things through other, things that I do and read and listen to and whatever. And they're the ones that keep having a political agenda throughout many of them. So I want to thank you for going through, taking all your time, because I think this took a lot of time on both our parts to give this kind of information today. I look forward to it. I want to thank the listeners because it's apparent to me that you appreciate what Richard and I are doing. Because when I look at my analysis, you often have us have this particular podcast near the top of the analyses that I receive about the podcast. So I want to thank the listeners and encourage you to continue listening to Hot Topic Bold Talk. So thank you very much, Richard.
Thank you.